Okay, I will dive straight in with my speech on the Court of Justice of the European Union. Ladies and gentlemen, as I'm sure some of you may remember, when studying a postgraduate course in conference interpreting, often we have the fortune to visit the large institutions that hire interpreters, such as the EU or the UN, for example. In the course of my MA program, we called this a study visit, and we visited the Council, Parliament, and Commission in Brussels. When we were there, we interpreted in a dummy booth and attended workshops alongside students from Stockholm University. It was a very enjoyable experience. So I was studying in Ireland, and this study visit took place in Brussels. So of course we had to get on a plane. We flew from Dublin to Brussels. And once we arrived, the Commission very generously provided us with accommodation for 3 days. We didn't just stay for 3 days. We stayed on a little bit more than that, made a bit of a holiday out of it. And all of the days that we spent after this study visit, we just fantasized about our future lives as staff interpreters at the institutions, a goal which hasn't been achieved quite yet. But I digress. This experience of this study visit, it was definitely a key element of the MA program. It really helped me to get through final exams, moments of doubt, harsh criticism from trainers. However, recently, I began to wonder how this would all work if I had been completing my MA in 2021 rather than 2019. The study visit would have been kind of difficult to carry out. It couldn't have involved an international flight, for example. I don't think it could have safely involved 3 trainee interpreters piled into a dummy booth, interpreting practically on top of one another. It really couldn't have involved a boozy bar crawl in Ghent. So how would it take place? This was my question. And fortunately, I received the answer to this question quite recently when I was invited to join on my alma mater's study visit to the Court of Justice of the European Union, albeit, you guessed it, this time in virtual form. Just like everything else now, I found out that not only are the students doing a virtual study visit to the CJEU, but also to the Commission, the Parliament, even the UN. So virtual study visits do have their benefits too. You get to visit more places in a shorter period of time. But I'm getting off topic. So to get back to the Court of Justice of the European Union, I very gladly accepted this invitation to the virtual study visit, and I'm very happy that I did, because it was an extremely informative talk, and it was presented by a staff interpreter at the court who is from Ireland, and the staff interpreter was both very knowledgeable and hilarious in equal measure. This staff interpreter talked to us about many things, including the different languages used in the court. He talked about his experience of going from working at the Commission to the Court of Justice. He talked about the particular difficulties that come with that, the different style of preparation at the Court of Justice, some of the training that they do, many things. However, one of the most interesting things that he talked to us about was the various cases that pass through the court. He tried to stress to us how these cases are applicable to real life. It's not all just hearings on some abstract provision of EU law, that some of the cases are, as I said, applicable to real life and very current and very funny in some cases. One of the cases he mentioned was where Lindt, the Swiss chocolate maker that I'm sure we're all familiar with, tried to trademark their gold bunnies, this chocolate product that they sell at Easter primarily. And it's very unsurprising that they tried to trademark this product, given that they sell around 90 million of these bunnies per year. Another interesting case that was brought before the Court of Justice of the European Union was one in which the court had to rule on where VAT, or value-added tax, was to be charged for pornography services created outside the EU, but consumed in the EU, for lack of a better or more appropriate verb. But of all of the cases mentioned in this study visit, the one that struck me most was the case of Baby S. like the letter S. And this is how the press are referring to this baby. Let me explain what's going on here. For a bit of background information, baby S was born in December in 2019 in a hospital near Barcelona, where her mothers live. And after she was born, she was issued a birth certificate in this hospital near Barcelona. This birth certificate listed both of her mother's names, one of which is Bulgarian and one of which is Gibraltarian. So baby S's mother applied for a Bulgarian birth certificate for her daughter. This was so that from this Bulgarian birth certificate, she could then get a Bulgarian passport, i.e. Bulgarian citizenship. This was unsuccessful. Why? Well, this is because the Bulgarian authorities, when she was applying for this birth certificate, apparently told her that a baby could not have two mothers. This is quite shocking, but it does line up with the fact that Bulgaria's constitution, as far as I know, defines marriage as the union of a man and a woman. As far as I understand the situation, the forms for applying for a Bulgarian birth certificate list mother's name and father's name. There is no room for movement otherwise. And the result of this is that baby S's family is powerless under administrative law. It's a very administrative problem here, but also a problem of constitution and beliefs and discrimination. However, this strikes me as blatant discrimination on the basis of sexual orientation. And I am pretty sure that discriminating against someone on the basis of sexual orientation flies in the face of Article 21 of the EU Charter of Fundamental Rights. Pretty sure. In any case, the family cannot get Bulgarian citizenship for baby S right now. So what do? What are their options? They could acquire Spanish citizenship, as difficult as that is to say, for baby S. Of course, she was born in Spain. Why not? This seems like a good idea also, because Spanish nationality would grant the same rights as Bulgarian nationality in terms of freedom of movement within the EU, working in the EU in the future. When looking at this situation, I thought, great idea, Spanish passport for baby S, perfect. Of course, she will be granted Spanish citizenship being born in Spain. But alas, that is not the case. If a baby was born in Ireland, for example, they would automatically have the right to Irish citizenship, regardless of their parentage. But in Spain, there is a series of other conditions that must be fulfilled for children born to non-Spanish parents, I believe. So that lands baby S in a bit of a sticky situation. So we have no Bulgarian citizenship because of blatant discrimination and administrative law. Because of nationality law in Spain, baby S can't get a Spanish passport. So what other options do the family have? Well, as you remember, one of baby S's mothers is Gibraltarian. As I'm sure many of you know, Gibraltar is technically the UK. I don't have the right terminology. I believe it's an overseas territory of the UK. So, of course, you think, yes, baby S could get a British passport. It may not be as ideal as a Bulgarian or Spanish passport in terms of working in the EU, future freedom of movement, or possibly, who knows, visiting grandparents in Bulgaria, but baby S needs a passport, and surely she should have the right to a British one. Her mother is Gibraltarian. Wrong again. Unfortunately, baby S's mother cannot pass on her British citizenship as she acquired it by descent and not by being born in the UK. So, what to do with baby S? You have Bulgarian, Spanish, and British law placing baby S in a strange situation where she could be at risk of prolonged statelessness. Prolonged statelessness could impede her ability to access healthcare, education, or work in the future, and this cannot be allowed to happen. Her Bulgarian mother's lawyer will urge the Court of Justice of the European Union to request that Bulgaria provide baby S with a birth certificate and subsequently Bulgarian nationality. And I don't know about you, but I think that this is quite reasonable. While the restrictions of all three countries' laws are placing baby S in a precarious position, only one of these is doing so out of blatant homophobia. So, in my humble opinion, I believe it is Bulgaria who should budge. Thank you.